Imagine for a second that you are part of a legal team that believes it has mapped out every single threat, every single obstacle, and every possible landmine on the horizon. You've spent years litigating in the public eye, fighting every motion, and preparing for every contingency. And then, in a single, heart-stopping moment, the ground beneath you doesn't just crack, it disappears entirely. That is exactly what happened when the Supreme Court dropped a legal bombshell that has left Donald Trump and his entire inner circle absolutely reeling. This wasn't just a loss. It was a total calculated blindsiding that no one, not the lawyers, not the political advisors, and certainly not the former president himself, saw coming. In a ruling that has sent shockwaves through the very foundations of the American legal system, the highest court in the land has revealed the existence of a secret shadow investigation that has been closing in on Trump for over a year. Before we dive into the staggering details of this ambush ruling and what it means for the future of the country, I need you to do me a massive favor. If you want to stay informed on these high-stakes stories that the mainstream media often skims over, please like this video, subscribe to the channel so you never miss an update, and share this with anyone who needs to know what's really happening behind those closed doors in Washington. And most importantly, I want to hear from you. Leave a comment below. Do you think the Supreme Court is right to keep investigations secret when national security is involved, or should everything be public from day one? Let's get the conversation started. The magnitude of this situation is honestly hard to fathom. We aren't just talking about a new development in an existing case. We are talking about the revelation of an entirely separate parallel legal front. Legal scholars are calling this unprecedented, and for good reason. The Supreme Court didn't just reject an appeal from Trump's team. They pulled back the curtain on a sealed grand jury investigation that has been running in total silence for months. While the world was focused on the classified documents in Florida or the election interference cases in D.C. and Georgia, a secret proceeding was moving through the federal courts, hidden from the press, hidden from the public, and remarkably, hidden even from Trump's own public-facing legal team. The court's order is absolute. Trump must comply immediately with a subpoena for financial records and private communications that his attorneys didn't even know were being sought. This is a moment where the legal landscape didn't just shift, it was completely rewritten in an afternoon. To truly understand why this is such a catastrophe for the Trump camp, you have to appreciate how the Supreme Court normally functions. Transparency is the bedrock of the court. You can usually see the cases coming from miles away. They are docketed publicly. Oral arguments are scheduled months in advance. The briefs are available for any citizen or journalist to read and analyze. There is a rhythm to it, a predictability that allows legal teams to strategize and prepare. But the law allows for a trapdoor in rare, extraordinary circumstances. When national security or highly sensitive ongoing investigations are at stake, the court has the authority to move in total darkness under seal. This is a power used so sparingly in our history that its application here suggests something truly explosive is being investigated. According to the ruling released on December 7th, this secret battle actually began over a year ago. A grand jury working in the shadows issued a subpoena for a massive trove of Trump's personal and business data. Because it was issued under seal, the very existence of the demand was a legal secret. Trump was served, but he and his attorneys were legally prohibited, gagged, from mentioning it to the press or the public. Think about the psychological weight of that. While Trump was on stage at rallies decrying his public persecution, he was simultaneously fighting a losing, invisible battle against a subpoena that sought the very heart of his private empire. He challenged it every step of the way, arguing for the same presidential immunity that he's used as a shield in his other cases. But one by one, the courts rejected him. The lower court said no. The appeals court said no. And finally, the Supreme Court delivered the ultimate no in a ruling that didn't just demand the documents. It announced to the world that the fight had been happening all along. The opinion, authored by Chief Justice John Roberts, is being described as a legal masterpiece of finality. Roberts made it clear that the materials being sought involve conduct that falls entirely outside any plausible claim of presidential immunity. The court essentially told the former president that his attempts to delay, obstruct, and play games with the legal system have reached their absolute end. There are no more appeals left to file, no more procedural maneuvers to hide behind. This is the end of the road. And according to the analysts who have scrutinized the language of the ruling, this isn't just more of the same. This appears to involve evidence separate from January 6th, separate from the Georgia election case, and separate from the Mar-a-Lago documents. This is a fourth major legal front, an X factor that has been lurking in the shadows, waiting for this exact moment to emerge. It is the element of complete surprise that makes this so different from everything else we've seen. Usually Trump has time to prepare the battlefield. When the court ruled on his immunity claims earlier this year, his team had already gamed out the outcomes. When his tax returns were subpoenaed years ago, it was a slow-motion car crash that they had time to brace for. Even Richard Nixon, during the height of the Watergate scandal, knew the Supreme Court was coming for his tapes. He had time to weigh his options, time to think about his legacy, and time to eventually resign. But Trump's team woke up on December 7th thinking they were fighting 3 or 4 major battles, only to find out by noon that they had already lost a 5th one they didn't even realize was at the Supreme Court yet. The reporting coming out of the New York Times paints a picture of pure, unadulterated chaos. Trump's lead attorneys reportedly learned about the ruling from news alerts on their phones, not from a court notification. Because the proceedings were sealed, the normal channels of communication were restricted. One source described the scene at Mar-a-Lago as absolute pandemonium. Lawyers were scrambling, phones were ringing off the hook, and the former president was reportedly demanding answers that no one had. They were suddenly faced with a 72-hour deadline to compile millions of pages of documents spanning a decade of business dealings. As we speak, the clock is ticking, and the pressure is unlike anything they have ever felt. We are at a turning point in this story, and things are about to get even more intense as we look at the specific documents the government is after. But before we go any further, I want to remind you to like this video and subscribe if you find this deep dive helpful. We are working hard to bring you the facts in a way that makes sense. Also, don't forget to share this on your social media. Let's make sure people are aware of the 72-hour rule the court just imposed. And tell me in the comments, do you think 72 hours is enough time for a legal team to process 10 years of records, or is the court being intentionally harsh? Let me know what you think. So what exactly is in this vault that the Supreme Court just forced open? The ruling, which is now partially public, identifies 3 terrifying categories of evidence. First, we have the financial records. This isn't just a few tax forms. We are talking about every single transaction, every loan term, and every property valuation involving foreign entities dating all the way back to 2015. This goes right to the heart of the allegations of money laundering and financial fraud that have followed the Trump organization for years. If there is a money trail connecting the former president to questionable foreign actors, these documents will contain it. Second, the subpoena demands all communications between Trump and certain foreign nationals. Here is the kicker. The names of these individuals are currently redacted in the public version of the ruling. The court cited national security concerns as the reason for the secrecy. That language is a massive red flag. It suggests that these aren't just business partners. They may be individuals connected to foreign governments or intelligence services. Analysts are already speculating that this could involve anyone from Russian oligarchs to officials in the Middle East. The fact that the Supreme Court itself is shielding these names tells you exactly how high the stakes are. The third category is perhaps the most explosive. The ruling describes a demand for documents related to efforts to obtain things of value from foreign sources in connection with electoral activities. In plain English, they are investigating whether the Trump campaign received illegal foreign support. Federal law is very clear. You cannot solicit or accept anything of value from a foreign national for an American election. If these documents show a quid pro quo or illegal financial backing from abroad, we are looking at a level of criminal exposure that dwarfs anything else currently on the table. This isn't just about mishandling a file. This is about the integrity of the American democratic process itself. The logistical nightmare for Trump's defense team cannot be overstated. They are being asked to do the impossible. They have 3 days to review a decade's worth of records for attorney-client privilege and executive privilege, knowing full well that the court has already signaled it has zero tolerance for more delays. According to Politico, one of Trump's own lawyers described the task as trying to empty the ocean with a teaspoon. If they fail to meet the 72-hour deadline, the consequences are immediate and severe. The Supreme Court took the extraordinary step of warning that any failure to comply in good faith will trigger civil and criminal contempt proceedings, and the court didn't stop there. They specifically mentioned pre-trial detention as a possible sanction. Let that sink in. The Supreme Court of the United States just told a former president that if he stalls, he could be put in a jail cell while he waits for his day in court. This shows a court that has finally reached its breaking point. For years, they have watched as the legal system was treated like a political chessboard. They've seen the attacks on judges, the defiance of orders, and the endless stream of emergency motions designed to run out the clock. This ruling is the justices saying, enough. They are no longer willing to tolerate the circus. And Trump's reaction, predictably, was like a volcanic eruption. Reports from CNN and MSNBC suggest he was screaming at his staff, throwing objects, and searching for someone to blame. He took to Truth Social almost immediately, launching a scorched earth attack on the justices, including the very ones he appointed to the bench. He called it a sneak attack and suggested Chief Justice Roberts was compromised. But as former federal prosecutor Andrew Weissman pointed out, these public outbursts are a gift to the government. By announcing to the world that he views the order as illegitimate and unconstitutional, Trump is handing prosecutors the evidence they need to prove willful defiance. If he doesn't hand over the documents by the deadline, he can't claim it was a logistical error. He's already told everyone he doesn't intend to comply. He has effectively confessed to the intent required for a contempt charge before the deadline has even passed. This leaves him in a position where every single path leads to a disaster. If he complies, the smoking gun is handed over. If he defies, he faces a jail cell. If he tries to delay, the court has already shut the door. The shockwaves from this are tearing through Trump's political circle as well. The Washington Post is reporting that his allies are in a state of near panic. The terrifying question they are all asking is, what else is out there? If the Justice Department could keep a Supreme Court-level investigation secret for a year, what other sealed cases are currently moving through the system? This uncertainty is a psychological nightmare for a campaign that relies on controlling the narrative. You can't control a narrative when you don't even know what the next chapter is. To make matters even worse, the internal structure of his legal team is crumbling. Reports indicate that at least 2 of his attorneys are considering walking away. They feel betrayed because they weren't kept in the loop about the secret proceedings. Representing a client who hides the most dangerous parts of his legal exposure is a professional suicide mission. And if they quit now, Trump is in even deeper trouble. Finding top-tier lawyers who are willing to jump into a 72-hour emergency with a client who attacks the court is getting harder by the day. Plus, the cooperating witness, the one who previously turned over leaked audio, is reportedly giving prosecutors a roadmap to these secret documents. They know exactly what should be there. If Trump tries to delete files or lose a laptop, they will know immediately. This isn't just a legal setback. This is a fundamental challenge to the idea that a president is a king who can operate above the law. We're looking at potential violations of the Foreign Corrupt Practices Act, money laundering, and campaign finance crimes that go way beyond inflated property values. Legal experts like Lawrence Tribe are comparing this to the most significant moments in constitutional history. Even conservative commentators like Jonathan Turley, who often gives Trump the benefit of the doubt, are calling this an existential threat. When the people who usually defend you start using words like existential, you know the situation is grave. As we look toward the final hours of this 72-hour countdown, the future of American democracy feels like it's hanging in the balance. This ruling establishes a precedent that future leaders will have to live with. It says that the publicity defense has its limits. It says that national security trumps political theater. And it says that the Supreme Court, for all its internal divisions, will still defend the integrity of the judicial process when pushed to the edge. The question now is, what will those documents show? Will they reveal a web of foreign influence that changes how we see the last decade of American politics? Or will they lead to a confrontation that sees a former president behind bars for contempt? Whatever happens, the world is watching. The clock is ticking down second by second. The Justice Department is waiting at the door. And Donald Trump, for perhaps the first time in his life, is cornered with nowhere left to run. This is the moment of truth that he spent a year trying to prevent, and it's arriving with the force of a hurricane. Thank you so much for sticking with me through this deep dive. This is one of the most complex and fast-moving stories we've ever covered. If you want to stay on top of what happens when that 72-hour deadline expires, you know what to do. Like this video, subscribe to the channel, and share this script with your friends and family. This is history in the making, and we are going to be here to break it down for you every step of the way. One last thing. Head down to the comments and tell me, if Trump goes to jail for contempt, how do you think it will affect the upcoming election? I'm looking forward to reading your theories. I'll see you in the next one.